a plea agreement. Is that accurate?
Yes, Your Honor.
And Mr. Miller, it is your decision and choice to voluntarily enter a guilty plea consistent with this offer.
Yes, sir.
All right, place your left hand on the Bible here in front of me.
I'll have to bring
Oh,
it
I'm
to you.
sorry. Never mind. No, that's fine. Don't. That's fine. It's not necessary. I didn't realize he was restrained. I'm sorry. Do you swear the testimony you're about to give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. Mr. Gander, would you recite the plea offer into the record, please?
Yes, Your Honor. In indictment number 17 CR 30, in exchange for a plea of guilty, the Commonwealth offers to amend the charge of robbery first degree down to facilitation to robbery first degree and offers 5 years. For the charge of theft by unlawful taking of a firearm, the Commonwealth offers 5 years. And for the charge of possession of a handgun by a minor, the Commonwealth offers 12 months. These are all to run consecutively to each other for a total of 10 years. The Commonwealth is opposed to probation. The defendant shall pay restitution in an amount to be determined by final sentencing to the Christian County Sheriff's Office. And the defendant shall testify at trial of his co-defendants and shall provide a written statement of his testimony to the Commonwealth. And he has provided the written statement I have here.
All right. Now, facilitation to robbery in the first degree is a Class D felony, and 5 years is the maximum sentence on that charge.
Yes, sir.
And theft by unlawful taking of a firearm is a Class D felony, and 5 years is the maximum sentence on that charge.
Yes, sir.
And possession of a handgun by a minor is a Class A misdemeanor, and 12 months is the maximum sentence on that charge.
Yes, sir.
All right, so the theft charge and the possession of a handgun charge by a minor, those charges have not been amended by the Commonwealth.
That's correct. Just the robbery first
The
degree.
robbery first degree is amended to facilitation, a Class D felony. All right. Mr. Miller, is there any physical, mental, or emotional issue going on in your life that would keep you from focusing on the importance of your court appearance today?
No, sir.
You understand what's happening and the significance of accepting the Commonwealth's plea offer.
Yes, sir.
Are you fully aware of the facts of your case, the evidence against you, and any defenses that you could make to a jury if you stood trial?
Yes, sir.
Do you know your sentence range and parole eligibility?
Yes, sir.
Are you satisfied with the way Mr. Bowling has investigated and evaluated your case and advised you about your options?
Of course, sir. Yes, sir.
Do you feel like he has effectively negotiated with the Commonwealth in your behalf?
Absolutely, sir. Yes, sir.
Any complaints you have about him must be addressed now as far as his lawyering is concerned. Do you have any complaints?
No, sir, I do not.
Do you need to ask him any questions or talk to him about any aspect of your decision?
No, sir.
Do you believe this voluntary agreement is fair and the best chance you have to settle your case, even if it means giving up your right to be tried by a jury?
Yes, sir.
Your decision's personal, and you must assure me that nobody has forced, threatened, or intimidated you.
No, sir.
So you've fully discussed your options with Mr. Bowling and decided that this agreement satisfactorily settles your case.
Yes, sir.
Are you sure you are making the right decision in your own best interest?
Yes, sir.
Is your plea guilty or not guilty?
Guilty, sir.
Mr. Bowling, does your certificate on Mr. Miller's guilty plea motion accurately reflect your professional opinion that his decision to plead guilty is knowing, intelligent, and voluntary?
Yes, Your Honor.
I agree, and so fine.